So I've noted a number of questions for the two of you, but we'll go and come back. Yes, Bobby, what do you see? Is Afenyo in any error by saying judges should stand united? GBA, you are a member of the GBA. Of course, Afenyo is a member of the GBA. Calls his peers that we should stand up. Yes, we're all. We should stand up and be heard and resist the attempt to remove the Chief Justice. He talks to the judges and say, don't be excited about it, because if you get to be the Chief Justice, if Justice Tokono is removed, you may suffer the same fate. Inusa is bringing up a number of questions. It's as if it is guaranteed that the CJ will be removed, and that if the CJ is removed, whoever will come will commit sins that can trigger 146, and so that person too can be removed.
Very. He
talks about the lawyers who are taking up the matter. The Chief Justice is not in court. It is Vincent Asefwa and one other gentleman, Daniel something, who are in court questioning the process. Asefwa is an MPP MP. He's entitled to take Godfrey Dame as his lawyer. What's wrong with that?
As I'm saying, good morning. I think that this whole issue with the current Chief Justice should, as Dr. I think Pumpuni said, should lead to legislative reforms for me. Because otherwise it will become a political ping-pong of NDC MPP. At the end of the day, the institution itself is what will be bastardized. Unfortunately, we've had a situation where the country is so polarized on political lines.
Just a second for me, and let me bring this to the attention of our viewers and listeners ahead of time. We apologize that in the course of this show, we will go to Kwehu to listen to the president for some 20 minutes. And because of that, the show has also been extended by some 30 minutes. There is a business summit going on in Kwehu, seeking to enlist about, 900 or 600 business people to seek to see what development they can bring to bear, not only in Kwehu, but the whole of the country. And the president will be speaking. There'll be 20 minutes of that will be taken by Newsfile.
Okay. So if we are not careful, and whatever happens with this current petition, it may leave a sour, taste in the minds of people who are interested genuinely in building institutions. The point I was making is that unfortunately in our country now, there's high-level polarization on political divide. In fact, there's more division on political lines than, I dare say, on even tribal or whatever lines. Now, if you look at the executive and the legislative arms of government, in the last parliament, it was so polarized that for about 3 months, there was no sitting because of the hanged parliament. The only institution of state that the framers of the constitution intended to step in, for lack of a better word, to resolve some of these issues with the level of independence is the judiciary. Now, for me, Article 125 says that justice emanates from the people of Ghana. And so we, the people, are ultimately responsible for safeguarding and promoting the independence of the judiciary. Of course, by using the procedure and the processes set out in the Constitution and other instruments of law that governs that scenario. There is absolutely nothing wrong with any citizen at all filing for the petition of the Chief Justice. The Constitution provides that it must be on these grounds. The Constitution went ahead to provide for the procedure to be used by the President in consultation with the Council of State. It was not until a J2 that the Supreme Court said there is a gap in that Article 146. It came about as a result of another challenge by a citizen. And so I will not necessarily fault Vincent Asefwa and his lawyers, for lack of a better word. If you take away their political division, because I don't think Vincent Asefwa filed the suit and he put there in his capacity as I'm doing it as MPP. He said he's a citizen of Ghana. Perhaps, the relief that he is seeking, the same way as was done in Ejechum, because before Ejechum, we didn't say that there was that gap that needed to be filled. So perhaps with the relief that Vincent Asifua Honorable is seeking, it may lead to another interpretation or application of that constitutional provision that may add another layer to the process, or it may not. So I will not want to fault them necessarily for taking that step. Just as every citizen of Ghana has the right to petition for the removal of the Chief Justice, the same way Article 2 guarantees the right of every citizen to bring a writ in the Supreme Court for interpretation and application of the process. Now, in these times, my challenge is that, and Honorable Fuseni spoke about the integrity of the process. I think that the framers of the Constitution, perhaps at the time they were saying these proceedings ought to be held in camera, looking at the times that we are in, that provision may not really be helpful. And the reason for me saying is that we have seen on social media commentaries by persons from both sides of the political divide seeking to adduce the contents of the petition.
Not only on social media, on traditional media
as well.
Yeah.
Now, nobody is chesting out to say that I have the document. This is what he says. But they are saying, you read things like...
The documents have been leaked.
I have not seen it.
But it is up to those who have received the leaked document to decide what they do with them. If you leak them to me, I will not use them.
Then that is where the problem arises, because the Chief Justice, I don't think would want to issue a statement to say that, listen, I have read so and so and so on mainstream and traditional media saying that these are the contents of the petition. This is not the content. This is actually the content. I don't think that the presidency will also issue a statement to say what you are seeing on social media is not the content. And that leaves a lot to be desired. Because at this stage, to the best of my knowledge, we may all be speculating as to the content of the said petition. And so if Honorable Afenyo-Markin says that the GBA and the judges should stand up against the attempt to remove the Chief Justice, maybe he has his foot on what the content of the petition is. I do not. I can only speak to the procedure that the Constitution says should be followed.
In fact, in the press comment, he suggested that the grounds or the things that are being used to trigger the petition are sort of frivolous. And you would have heard also former First Deputy Speaker, Joe Wise, also say that if what he has seen to be the content of the petition are what they are, he doesn't believe that they should end up in removing a Chief Justice. And in traditional media, you have heard, for example, Paul Admochre also talk about one of the petitions. There are three. Talk about one of the petitions, and he lists a number of grounds. Even though he listed about three, that particular petition is supposed to have in excess of 21 plus, I think, 4 different grounds. But he picked about 3 or 4 and gave responses to them. And the people are making their minds around some of these things. Therein
lie the attack on the integrity of the process. Because now the framers in 1992 perhaps did not anticipate that there will be proliferation of media or information to this extent that these days when you write something to the presidency, before you, the person who went to submit it, you leave, is already on social media. And that is worrying. And so you see the Chief Justice in a certain situation. I was in court once where an objection was raised to the constitution of a panel at the Court of Appeal. The panel. The basis of the objection to the constitution of the panel was that one of the parties in the case was, for lack of a better word, the spiritual father of the Chief Justice. And so for that reason, an objection had been raised to the constitution of the panel. And this matter had to be adjourned for the Court of Appeal judges to deliver a ruling. And so sometimes you have some of these things being thrown in where it will be very difficult to justify or to support them. Some of the people that I've seen made comments on social media about the alleged contents are people that in the past have made comments against government institutions, government appointees, they've not backed it up with any evidence when they were called to. And so I sit and I say, okay, in the past you said A, B, C, D. There's no evidence. Now you are saying this. It leaves me or any person who is interested in following the integrity of the process challenged. So I will suggest that perhaps going forward, with the consent of the parties involved, it may be necessary for the contents of the petition to be made and the response with the consent of the parties involved. Because we can't shy away from the fact that whether it is formally made public or leaked, once there is a petition against the Chief Justice, there is a questioning of the administration of justice under that particular Chief Justice.
Interesting. If the president is going to be impeached, we'll know the content of why he's going to be impeached, and it will happen in Parliament.
Yes. Yeah.
And so if the Chief Justice is almost on the same level of a removal process,
why should it
should be made public?
That is my...
But presently, in Utaderi, the Supreme Court gave a caution that if it is leaked, there can be consequences.
Yes.
The consequences can include a suit in torts, a declaration to the breach of the provision, and even criminal sanctions.
I agree. That is why I'm saying that going forward, the framers, or because the Constitution is under review, it may become necessary that with the consent of the parties involved, to avoid some of these... No, it may, because as it stands now, the speculation is fueling what it is not.
Let them fuel it.
But at the end of the day,
I think so.
No, at the end of the day, the ordinary person...
These are, excuse me, I mean, busy, good for nothing busy.
We'll come to that, and to the point that actually a poll has been conducted.
I was going to go to that. The 51 or a certain percentage are in support of the removal. But have they seen the content of the petition?
Definitely not.
That's what I'm saying.
That was the point I was going to make. Comes out to say that he has undertaken a poll.
The contents have been leaked.
I have not seen it.
Social media.
Oh, I have not seen it. I have not seen it.
But the interesting thing is that the contents of the petition, which were submitted to the presidency, have been leaked. But fortunately, the responses of the Chief Justice
have not.
So there's an integrity when it comes to the part of the Chief Justice.
Yes.
But there's no integrity when it comes to the part of the presidency.
How do you say
that? Please, I'm making my point. And so, whatever happened, the petition went to the president.
But there are more than one petition.
There are three
petitions.
So according to our constitution, when it comes to the petition for the removal of the, what do you call it, Article 146, Clause 6, the petition is submitted to the president, isn't it? So if we are going by that, then that is where the petition was submitted, and that is where
the fallacy is.
Took place.
That's where
what upsets me is that when it came to the petition, there was no integrity in providing confidentiality and sanctity to the grounds of the petition. But when it comes to the Chief Justice, her integrity must be assured, because she could also have leaked her responses, especially if the responses were saying no to each of the grounds of the petition. So in this case, I believe that we must educate the public that when you hear one-sided version of a legal matter, please keep quiet. Don't jump to conclusions, because in law, we have something called let's hear the other side. The one that, it's a long sentence in
Latin.
Audi alteram patent. But once you hear the word alteram, you know it means look at the alternative. Yeah. So please, public, if you are listening to me, when you hear a one-sided petition, keep quiet. Let's also be patient and hear the response. If the response has not come from the Chief Justice, that means the petition has been leaked, in what do you call it? And it's contrary to that hearing the other side. So let's hold on there.
The question
I don't want to use the word or
the question I'm raising to you now.
So please, let's hold on when it comes to the petition.
No, so the question I'm raising to you now is
for the other side.
Okay.
Please.
So,
unfortunately, the other side coming from the CJ have shown and proven integrity to the process.
Okay.
And I appreciate that next time there's something like that, the other side, that's the presidency, also oppose integrity.
No, your assumption is fundamentally
I'm not assuming. I'm looking at the constitution.
No,
it's not an assumption.
Wait,
it's a constitutional basis.
Let's hear
So
the
please,
example.
don't use assumption. Let me give you the
listen to me. Listen to me.
No. Yes.
What I'm saying is that your assumption.
So we have established.
Assumption the constitutional.
Hold on.
It's a constitutional.
No, hold on. We have
it's
established.
You know, I'm not just presuming.
No,
Article
all three before you have established that it is supposed to be a private and confidential process. So that is not a matter in argument.
Yeah, so what happened?
The question you have done, what you have done now, is a presumption or an allegation which now has to be interrogated. That has nothing to do with the provision of the Constitution.
I will say no.
So say what you want to say.
What I'm saying is that
I say no.
She's assuming
no to the presumption and absolutely no to the
then you
assumption.
should open your you should open up your mind to what people
No, I'm using a constitutional basis.
I have a constitution.
Where did the petition go to? Where was it submitted?
Is the president who wrote the petition?
So where did the petition go to? So you believe that you can look at the leakage? So wait. So are you saying that the leakage came from the people who wrote it?
Open your mind.
I'm also asking.
First of all,
is that what you're assuming?
The petition was written by somebody.
Are you also assuming?
That's the number one. Number two, the petition was forwarded to the Chief Justice. So the Chief Justice has the petition. What gives you the confidence to say that the leakage could not have come from this document sent to the Chief Justice? What gives you that?
So what are you saying?
What gives you that confidence?
So what are you saying?
How do you
Be specific.
How do you know that it was not a Chief
I have
Justice
zoomed in on what I am saying. So what are you saying?
Have not leaked it?
So tell us what you are saying. What are you suggesting?
So I'm asking you a question.
The leakage could come from one, the people who wrote the petition,
Presidency or the Chief Justice.
the presidency or the Chief Justice. That's what I'm telling you.
Do you agree? Do you agree that's a fair way to?
Suggestion. I have also made my suggestion. But
no, yours is not a suggestion. Yours is an allegation.
You said
I
integrity
my
of the process.
146.
No, it has nothing to do with the Constitution. It's an allegation.
I'm not in the court of law for you to judge me. I'm telling you that this is the basis
We all
of my
agree.
argument.
We all agree.
He also has his basis of his argument.
No,
but
nobody disputes. Nobody disputes.
Exactly, but there's
Nobody
one
disputes.
thing I want to emphasize.
If I may be heard, nobody disputes that the process has to be confidential. And I've actually gone ahead to say that the Supreme Court says if you leak it, there can be consequences for leaking it. So all the members on this panel agree that it has to be confidential. You are the one who has said with emphasis that the petition that has been leaked was leaked from the presidency. So that is an allegation.
Well, I'm saying that if you look at Article 146...
It has nothing to do with the article.
No. Let me also learn versus Clause 6.
You don't need the article to back up your allegation.
Okay? The probability of it coming from the presidency exists. There's a probability from it coming from the presidency.
Where is that?
Now,
where's the probability? Where is the probability?
Why do I have to repeat myself?
You cannot use the Constitution to back your claim.
Oh, please, then what do we use? Fantasy. The Honorable has also looked at the process and said the probability could be 3.
Okay.
I am using 1 and he's using 3.
Okay.
That could come from the office of the president or the, what do you call it? The petitioners themselves or the office of the
You did not say it could come. You said it came from the presidency.
I have used that probability.
Now you change your original position.
No, I'm telling you. Why are you trying to twist my mouth?
No.
Now,
wait.
I'm going on. I'm moving on.
I have to moderate this show. Hold on.
Uh-huh.
Did you say it could come from the presidency or it came from the presidency?
I used the word probability.
Probability. So you are not making an exact allegation that the presidency leaked it.
What does probability mean?
I'm asking you a question. If you answer that.
Why do I have to repeat myself?
You said that from the CJ's place. It is important. It is important. It is important. Please, and let me moderate this show. You said that from the end of the CJ, there's integrity. From the end of the presidency, there's no integrity. Are you changing that position?
I'm telling you that I'm still sticking to what I'm saying. That based on Article 146, Clause 6. I said the probability comes from the presidency. He says the probability could be 3. I'm saying that, well, he has brought in the 3. And so he has zoomed in on the one that I had, that there could be a probability, right? Probability that the leakage comes from the presidency. So he has more or less confirmed it.
Okay.
But let me land. But in this case, the Chief Justice has shown integrity by not putting it in the public domain, that this is my version of my response to these petitions. So I'll humbly ask the public, and also add education to the public, that please, when you hear one side on social media, let's wait for the other side. It happens in all legal situations. Whenever you file something against somebody in court, they don't rush to listen.
So let's do this. You actually truncated. You truncated Bobby.
Now I also
wait. You actually truncated. So
she just took it off.
That's okay. Sometimes it happens.
Yes, I was. Yes.
And I wanted to add.
Thank you. I will just again, for me, to the legislative reforms going forward. The constitution of the 5-member committee said 2 of them should be Supreme Court judges. Now, my practical challenge in this instance is that, and this is not definitive, just for the purposes of thoughts and discussions, if the 2 members of the Supreme Court, or the 2 justices of the Supreme Court, become members of this committee, and in the event that the committee at the end of their work decide that the Chief Justice is culpable in the petition and recommend that the Chief Justice should be removed. Sometimes I've been thinking, can any of these 2 members of the committee be candidates for the appointment of the Chief Justice?
Of course, why not?
Will it not suggest, like again, like I'm saying, legislative reform, will it not suggest? Yes. If any of them ends up being appointed a Chief Justice, will it not suggest that all along there were biases through the process?
Bobby, just a fundamental.
Let's hear Frank. Let's hear Frank. Yes.
We are all sitting here talking about integrity.
Yeah.
And integrity got my lady friend.
You guys are supposed to be brief because Gloria is now going to have a substantive, chance.
Bobby, don't let us bring the integrity of our justices of the Supreme Court into dispute. No. Excuse me. What the inference, the inference you are making from this line of argument is that if there should be a determination that the Chief Justice ought or should be removed after the constitution of the 5-member, whatever, the 2 justices of the Supreme Court, who invariably have no choice than to sit on it because that is what the Constitution says. Is it to suggest that they will not have acted with utmost integrity and fidelity?
No. I am saying this I'm suggesting legislative reform.
Because you see...
That is why I was making the point. Yeah, I'm saying that legislative reform...
Your point is let him finish it up.
If we are not guided by learners of the law and masters of the law, the whole process will be mutilated. Because the other 3 persons who are coming onto that committee are non-lawyers, not members of the Council of State, and they are not MPs. So this is going to come from the generality of the public. Anybody else can be appointed. Okay. But we need guidance. So, of course, it's a sticky situation. But where you have been called upon to perform a duty, we will suggest and think that there will be integrity and fidelity to the process.
I think the point I was making is that...
hold on a second.
I think that I support what he has said in the framework of a larger constitutional or
that is
legislative reform.
Yes,
reform. Look, if we are going to safeguard the integrity of the process, it should be said that the 2 Supreme Court judges who be appointed onto the committee must not qualify to be Chief Justice.
That's what that reform. That's what I'm saying. I'm not saying that
that's what he says. So that it doesn't create the
impression. Frank is suggesting to you that implicitly you are suggesting that judges can see facts
And then skew them.
Which exonerate and still say these are not exculpating, facts.
I don't think it's fair.
They may even force, a guilty verdict when there is no a guilty verdict.
No. What he's saying.
No, but how can you say because they have sat on the committee, they should be excluded from being appointed as Chief Justice?
That is the opportunity.
No, that is discriminatory.
No, that's the opportunity cost of sitting on the committee like that.
Again, all that I'm saying is for legislative reform.
It is like
going forward.
It is like you.
All that I'm saying
or
is
maybe those two persons should not come from the Supreme Court.
Perhaps that is what I'm saying. The committee, the constitution of the committee, may even be retired Supreme Court judges.
Maybe.
That is what I'm saying. So I'm talking about reform.
Thank you. Please land.
Maybe retired Supreme Court judges.
I need you to complete your submission.
Okay, so I'm going to complete it. Yes, that's what I'm saying. No, but I didn't finish and you jumped on it. So you said yes, to take away the perceived.
I just suggested that to you.
Yes. The last,
or even retired chief.
No. I'm saying,
or even retired chief justice.
Perhaps. The last reform that I think may have to look at going forward is the suspension and the revocation. Because we know, and sometimes I think we've discussed it here, that suspension in itself is a disciplinary measure, for lack of a better word. So it is not as if it is, I have not finished my investigations, but I have suspended you. Let me finish my investigations, then I can revoke the suspension. I think that provision may also have to be looked at. Because if you say for example, you are suspending the Chief Justice, that constitutional provision does not make any room for appeal.
No.
It does not. And the Supreme Court have said that appeal is not as of right. So unless it says that you have a right of appeal, you cannot. So what it means is that the final decision, which is not only an administrative decision to be taken by the President in consultation with the Council of State, it also becomes a judicial decision. Why? Because it affects the rights of a constitutionally appointed person.
But the absence of an appeal does not foreclose an action by someone who is aggrieved by the findings of
the committee.
A committee.
No, but at that time that they are suspending, the committee has not finished.
I'm not talking about that. When they are finished.
Yeah, of course, when they are finished.
The product.
You can
question it in a court of law.
If you say that due process was not followed. But even with that, I don't know if you can question the conclusion. Again, because of the strict interpretation of the right of appeals by the Supreme Court, that if there is a specific procedure and it doesn't state that you have a right of appeal, you can appeal within so and so. You do not.
No, I'm saying you can take your mind a bit away from appeal.
And then challenge it in terms of, well, let's see. So I think, yes, it may. So after this, if this does settle, I think that the Constitutional Review Committee should have a thorough look at that Article 146 to foster the integrity of the process.
Thank you.
Yes. As we are all thinking aloud, suspension, does it not align with interdiction?
Actually, there is a case law which we discussed on this show that it is actually a result of a concluded process. It's loosely referred to as step aside and let me investigate.
Yes.
But once you use the word suspension, it is a punishment. I'm using punishment loosely.
Okay. So it's just nomenclature. Thank you.
Yes.